Hi everyone, I'm Max Chaudhary, a Canadian immigration lawyer, and today I want to talk about an important issue that's been making waves in the immigration world: the recent changes to the practice of flagpoling for work and study permits at Canadian land borders. If you're a temporary resident in Canada or an employer relying on international talent, this is something you need to know about. In this first part of the video, I'll explain what flagpoling is, what's happening now, and how the new policy conflicts with the law. So, what is flagpoling? Let's start with the basics. Flagpoling is when someone already in Canada on a temporary resident visa, like a visitor visa, leaves the country briefly, usually to the United States, and then re-enters Canada to apply for a work or study permit at the border. This process has been a convenient way for people to get their permits processed quickly, avoiding the long inland or overseas processing times. It's been especially useful for those who already have job offers or who need to start school soon. What's happening now? In December 2024, there was an announcement that flagpoling would no longer be allowed for most work and study permit applications. This was followed by Operational Bulletin 686, which provides guidelines for border officials to refuse these applications at ports of entry. The CBSA's reasoning is that flagpoling creates operational challenges at the border, like long wait times and resource strain. But here's the problem: this new policy directly conflicts with the law. What does the law say? Under Section 198 of the Immigration and Refugee Protection Regulations, certain foreign nationals are explicitly permitted at ports of entry to apply for work permits if they meet specific conditions. For example, if you're from a visa-exempt country, you can apply for a work permit when entering Canada. This regulation has been in place for years, and it gives people the legal right to apply for work permits at the border. However, the CBSA's new policy essentially overrides this regulation by instructing border officials to refuse most applications, even when the law says they should be allowed. Why is this a problem? This creates a situation where, on the one hand, the law says you can apply for a work permit at the border under certain conditions. On the other hand, the CBSA is telling its officers to refuse these applications. This inconsistency is confusing for applicants, immigration lawyers, and even border officials. It also raises serious questions about whether the CBSA is overstepping its authority by implementing a policy that contradicts the law. That's it for part one of this video. In the next part, I'll dive into the practical implications of this policy for applicants and would-be employers, the broad policy consequences, and what needs to change. If helpful so far, don't forget to like, share, and subscribe so you don't miss part two. And if you have any questions, feel free to leave them in the comments below or email us to clerk@chaudharylaw.com. See you in the next video.